Okay, well, okay, let me share my screen here. And
David and Wendy, let's hit your mute buttons, please.
all right. Can everyone just see the screen itself? Fantastic. All right. So, as Mary said, I'm Tony Hinson, actually of counsel now with the Sherrard McGonigal Desano and Lind firm, meaning I'm associated with the firm, but I am no longer a partner with the firm. I've decided to enter a new phase of my career here, but very excited to work with them on tax issues and in general estate planning issues. So I am very closely affiliated with the Sherrard McGonigal Desano and Lind firm here in Paulsbo. Fantastic firm, great people, proud to be a part of it. Uh, I'm an attorney. We have to have disclaimers. It's just part of our DNA, I think. Really, this disclaimer just states that, we're not forming an attorney-client relationship today. I'm going to give you broad strokes. Please don't take massive changes to your plan based upon this presentation. Sit down with your financial planner, your attorney, your CPA, and all the professionals that should be involved before you make any major decisions like that. Well, I'm trying today to give you an overview so that you know which questions to ask and you know what you should be thinking about as you potentially redo or at least evaluate your current estate plan. My background, as you probably will be able to tell by the end of this, I'm a Tennessee native. I'm a Southern boy, Washingtonian by choice, I say. I moved out here, fell in love with it, and have not left. Went to Vanderbilt, University of North Carolina for undergraduate and law school. Spent 25 years in the Navy as a JAG, both active duty and reserve. Retired in February 2020, right before the world ended. So that's one of the few things in the Navy my timing was perfect on. I got out right before COVID. The other side, as I worked for the IRS for 9 years as an estate tax attorney. So I learned a lot of what I know about estate planning by examining plans of brilliant attorneys out there and trying to figure out what they were doing and trying to figure out if there were any issues with what they were doing, and really learned it from the ground up from some very gifted tax professionals. And I'm very grateful for that experience. And I apply it now to the good side of the force since I no longer work with the IRS. I'm not Iron Man. I just put that in there to see if anybody actually reads these slides. Do have two kids, 16 and 18. And I'm of counsel here with the Sherrard McGonigal, Desano, and Lind firm. Recently, as Mary may have alluded to, I married Amanda Grossman, who is down the street here at the Tolman firm. So two local attorneys hitched up. So we're both estate planners, and we managed to be competitors and yet stay pretty friendly. So life is good. First thing we're going to talk about today is basic estate planning documents. People tend to view estate plans as a will. And once you've got a will or a revocable trust in place, you're done. There's a lot more to it than that. Having a comprehensive plan for not just what happens after you pass on, but for aging, for successful aging, to have documents in place that allow people to come in and help you manage your affairs when you need that help. So that includes a will, a revocable trust, powers of attorney for finance and healthcare, a declaration to physicians, a living will if you so choose, and then additional documents, insurance trusts, retirement plan trusts, detailed funeral desires. Those can all be put in place as well. I want to make two small points on this slide. One is that will versus trust. I end up with a lot of clients, potential clients come in, and they have heard from a friend or know a guy who knows a gal who knows a guy, told them they have got to have a revocable trust. There's no other way around it. First thing I tell my clients is unless you own real property outside of Washington or there are other considerations that make your plan much more trust centric, I do the majority of my planning using wills. Probate in Washington is nowhere near the nightmare that it is in other states, and certainly nothing like the nightmare that people are told that it can be. Uh, by and large, the court stays out of the probate process in Washington, and there's not a huge amount of difference between administering a trust and doing a probate. And setting up a trust is more expensive. It's more time consuming, and it complicates things a little bit, particularly if you need a power of attorney to step in and help you manage your affairs. So absent a compelling need for a revocable trust, and there are some, I tend to do most of my plannings by will because probate is simply not the nightmare here that you've heard about it in other states. The last point is dealing with that community property agreement at the bottom of this slide. A lot of practitioners put those in place as a probate avoidance tool. They state three things: what we own is community property, what we're going to acquire is community property, and if one of us dies, everything flips over to the other. It's an agreement between spouses. If we have the detailed planning that I like to put in a will or a revocable trust for that matter, that last part can be problematic because it goes around the will, goes around the trust. So when I do a community property agreement, by and large for my clients, I put the first two provisions in place. Everything we own is community property. Everything we're going to acquire is community property. But when one of us dies, look to the will, look to the trust, and let that document determine what happens to what I own. So I do replace quite a few community property agreements with what I call a two-prong community property agreement to keep that community aspect in the marriage, but still allow these complex documents to decide what happens to your stuff when you pass on. So assuming we're going to go the will route, it is your basic estate planning document. It distributes your assets. What happens when you die? Where does your stuff go? And how does it get there? Does it go outright to the person, or do we have trusts established in your will, so-called testamentary trusts? I use those quite often. They're good for tax planning. They're good for Medicaid planning. They're good for planning for beneficiaries who might not be the best with money, or you simply want to be a little bit older before they acquire the property that you're leaving them outright. So within a will, there can be trusts, but those trusts don't come into being until you pass on. So they're testamentary trusts. They're there, but they don't really exist until such time as your will comes into being, which is basically when you die. Another thing we can do in a will is set guardianships and custodianships for minor children and dependent children of yours. You can state your preferences as to who would be their guardian or custodian, and the court will respect that choice unless there's a compelling reason not to. And then finally, that last bullet point, we do establish trusts within wills, but it establishes the trust when it's needed, which is after you've passed on. And then that trust can last either for someone's lifetime or for a term of years, or until some conditions are met that allow the trust to be dissolved. Second document is a durable power of attorney for financial matters. Basically, this document puts someone in place to manage your finances if you're not capable of doing so. This includes retirement accounts. It includes companies that you may run, closely held. It includes life insurance, making gifts, really anything you could do financially, your attorney, in fact, can do for you under this document. One key thing is whether or not this document is immediately effective, or does it become effective if you become incapacitated. If you're assigning a close relative or someone that you know and trust in this role, my recommendation is typically to make them immediately effective. That way we don't have to go through the process of trying to get a doctor's letter to certify that you're not competent to manage your affairs to trigger the document, the so-called springing power of attorney. I make most of mine immediately effective. That way, if circumstances come about where you need this person to step in, they can do so immediately. They don't need to get a letter. And if you're concerned about that much power with someone, completely legitimate, what I tell clients is let's take a step back and think about the person that you're putting this power in. If you're that concerned about it, maybe we talk about someone else or a professional fiduciary. If you assign a professional fiduciary in this role, then I would make the document springing just so it's very clear when everybody's role took place. This document can be extremely powerful for Medicaid planning for married couples. It allows the spouse who is still competent to transfer assets and do other things we'll talk about here in a few minutes, even if the spouse going into care is no longer competent to do so. So this is a critical document to have in place. If you don't have this, you may need to establish a guardianship and custodianship. That's expensive, it's time consuming, it's kind of onerous with court oversight. So this document takes the place of that. The one thing that you do guardianship is that you dictate who you want that to be, and the court will respect your choices unless there's a compelling reason not to. So you can put in place the fact that, hey, look, I'm assigning this person as my attorney. In fact, if I need a guardianship, then, Your Honor, I want this person to be my guardian. And in Washington, unless there's something that's happened in the interim that makes that person no longer appropriate, the court will respect your choice. Third document is a power of attorney for healthcare. Now, this document is someone that puts someone in place who can make healthcare decisions on your behalf if you can't. So in that way, this document is always springing. You're going to be making your own healthcare decisions until you can't. And once you can't make those, then this person steps in and makes informed consent decisions for you. People tend to think about it as an end of life kind of document, which it certainly can be. But this document covers the mundane stuff as well. You're no longer competent. You've got a cavity. We need to take you to the dentist. He or she is going to put some Novocaine in there to numb you up and drill a hole in your tooth. They need someone's consent to do that, and that would be your healthcare agent. So it covers the whole range of healthcare needs you may have, including up to end of life decisions. Now, your incapacity is temporary and you regain your ability to make healthcare decisions. This document goes back to sleep, and once again, you're making your own calls. Last document we'll talk about in detail is a living will. This is simply a document that states that if you end up in a permanent unconscious condition or a terminal condition where you don't really have cognition, and you're being kept alive by artificial means, and there's no likelihood that you're going to return to a normal state of being, then this document authorizes your healthcare agent to remove artificial means of support. If you're intubated, you've got dialysis going, you're being fed through a peg tube, various things that can be put in place to sustain your life. You authorize those to be removed to allow you to pass naturally. Now, you can still call for palliative care, so pain medication, anti-anxiety medication on the chance that you do still have some higher functions, as well as hydration. Most of my clients choose to keep an IV drip going just to avoid dehydration and to allow for administration of those palliative drugs. This doesn't have to be the same person who has been appointed as your healthcare agent, although it typically is. So that person then would make those decisions and authorize the doctors to remove artificial means of support, and then you pass away naturally. Nothing is done to end your life. Your body simply shuts down as it would have without the additional support. I want to be clear, this is not a DNR, as people know it, or a POLST, as we call it in Washington, a physician's order for life-sustaining treatment. That document, by and large, states that if you are no longer breathing or your heart is no longer beating, are we going to administer CPR to get you going again? Are we going to take measures to get you breathing and or your heart beating again? That can happen at any stage of life, really. A living will can. This is something that could happen to you in your 30s or 40s if you have a catastrophic health event. A DNR, in my opinion, is really needed for those folks who are very, very old or very, very sick and don't want to be resuscitated. And I use the example of clients I had a few years back who were both in their 30s with kids, and they had executed POLSTs thinking that they were living wills. So if this otherwise healthy 30-year-old had had a heart attack, that POLST would have stopped emergency medical professionals from restarting their heart, even though it might have been a fluke heart attack of someone in their 30s. So it's very important to keep a living will separate from a POLST, from a DNR. If you sincerely do not want resuscitation under any circumstances, then a POLST is the document that you'd want to complete after consultation with your doctor. POLSTs, the flip side of them, on the backside, they've got a lot of other functions, but in my non-medical opinion, they perform best as a DNR. And then if you have concerns about artificial means of support at end of life, have your physician's order, your living will or your directive to physicians in place to handle that. So I'll stop there, see if there are any questions about basic estate planning documents, and then we'll discuss estate taxes briefly.
There are none on the chat bar, Tony.
Okay, we'll roll right into everybody's favorite topic, which is tax. So, here in Washington, we have a standalone state estate tax, which means we have two taxing authorities. Now, that is a 40% tax on five is 13 million. Abs
I'm going to interrupt
fixed
for a
that
moment, Tony. Is everybody hearing him clearly, and is it just me where his voice is going in and out?
back.
It's going in and out for me too,
Okay,
and his screen has been freezing.
yeah.
Okay, am I back now?
Yes, you are.
Okay, sorry about that.
Okay.
So the federal exemption is $13,990,000. Anything over that is taxed at a 40% rate. Now, because of the way that the 2017 tax cuts were passed, that exemption, absent action by Congress, is going to be reduced down to probably somewhere around 7 million for 2026. Both big numbers, both exclude almost all of us from paying the federal estate tax. Here in a second, estate taxes might not be a big issue for a lot of us. What's included in that 13,990,000? Basically everything you control. It's more than just your probate estate, more than just your house and your bank accounts. It includes 401ks, IRAs, life insurance, lifetime gifts that you may have made that are over the annual exclusion amount. You can see there, last year it was 18,000 per year per person. This year it's 19,000 per year per person. So if you give someone over $19,000 in a calendar year, then you use a portion of that $13,990,000 credit to cover that gift. So lifetime gifts, as well as what you pass on at death, covered by the federal estate tax. The Washington estate tax is a progressive rate. It starts at 10% and it goes up to 20%. And it's taxed on assets over $2,193,000. So a much lower figure, thankfully a lower tax rate. But whereas the federal exemption increases each year for inflation, the Washington exemption is frozen, at least for now, at $2,193,000. So if you own a house, you've got a retirement account, and you have a life insurance policy, you're going to be a lot closer to that figure than maybe you think you are. And some Washington estate tax planning is needed to try and make sure that we pay as little tax as possible under the law. And with just a few simple techniques that we'll discuss, we can make sure that you're paying the proper tax and not paying too much. Now, again, there's that exemption is fixed for the near future. There's no indication that that the legislature is going to fix a little problem that's got it frozen. The upside is there is no gift tax in Washington. So you can give away with $93,000. So gifting is a viable strategy for Washington in that if you give it away and it's gone, it's complete, then it doesn't count, again, with some limited exceptions, towards that $2,193,000. So gifting is often a pretty viable strategy for trying to minimize the Washington estate tax. Now, when do I start worrying about the estate taxes? With the feds, between 2 and 4 million, if either a single person or a married couple has assets in that range. Why the 4 million? Why the 2 million? Well, because there are proposals every few years to reduce the federal exemption down to the 3 million, the 2 million range. And who knows, those may gain traction in the near future and we may see a much smaller federal exemption. So I start thinking about the federal side of it in the 2 to 4 million range. Now, certainly age has a lot to do with it. 95-year-old with $2 million is a lot different than a 45-year-old person with $2 million, just in terms of planning horizons and whatnot. But that's when I start really thinking about the federal estate tax. Washington, once you cross the $1 million threshold, you're halfway there. And again, because that exemption is fixed, at least for the time being, your assets are going to continue to increase in value, hopefully, just with simple appreciation. And that exemption stays fixed at 2.193 million. So once you start going over the $1 million range as an individual or a couple, I start worrying about the Washington estate tax as well. Why is that? It's because of the danger of the I love you will. The I love you will being that traditional document that states when I pass on, everything I own goes to my spouse. And if my spouse has predeceased me, then to my kids, equal shares, share and share alike. It's a very traditional will. And from a tax perspective, it can be a disaster. What it does, unfortunately, is it only uses, I'm seeing the unstable again here. It only uses one spouse's exemption amount. So what can happen in that circumstance, in a $3 million estate, the decedent passes on. They've got a 1.5, and that goes to the surviving spouse. No problem with the first death because there's an unlimited marital deduction for that entire 1.5 million. The problem is now the survivor's got a $3 million estate, and we only have a $2.193 million exemption to apply against it. We didn't use any of that first spouse's exemption, which would result in Washington estate tax of about $81,000 on a $3 million estate. And that really is the danger of the I love you will. Now, on the Fed side, there's a potential fix for that. The feds will allow you to file an estate tax return when the first spouse dies and grab the credit you didn't use and use it during your lifetime or at your death. It's called portability. It's a very helpful tool. If you failed to plan, you can still kind of, it's not quite as efficient as setting up a trust or something, but it's a nice way to at least make sure you've got both credits available to that surviving spouse. However, there is no portability of the Washington exemption amount. So you either use it when the first spouse dies or you lose it. You don't use it, in which case you're stuck with the one credit of the surviving spouse. So what do we do to plan around and try to make sure we use both credits? Well, we use something called a credit shelter trust. Same example, $3 million estate, first spouse dies. I'm getting a feedback here. Hey, Bill, can you go on mute for me, please?
Yes.
Okay, thanks. Instead of, I'm still getting a balance for some reason, that's okay. Instead of the 1.5 million going directly to the surviving spouse, in this example, it goes to a credit shelter trust. That credit shelter trust does not qualify for the marital deduction. So we've got a 1.5 million taxable estate, but we use the first spouse's credit on it. 2.193 is greater than 1.5, no estate tax. Now, when the surviving spouse dies, that credit shelter trust is not included in their estate because it's already been taxed. So their half, 1.5 million, they use their own 2.193 million credit against it, and there's no estate tax there either. So what you've effectively done is given yourself the opportunity to use both credits. Now, the terms of the trust, very, very liberal. Typically, the surviving spouse is the trustee. They get all the income from the trust. They can dip into the principal if they need to for health, education, maintenance, or support. Very, very broad standard, but just enough, can't go to Vegas and bet it on red, just enough to keep that trust from being included in the estate of the second spouse. But by and large, it's transparent to the surviving spouse in terms of their lifestyle and their ability to live their life. And it's a very powerful tool, again, to allow a married couple to use both of those credits. So estate tax takeaways, because of the low exemption in Washington and the fact that it's fixed, really should start thinking about the Washington estate tax. Credit is likely to decrease substantially unless Congress acts this year to extend the tax cuts for a number of years or make them permanent. So really, flexibility is the key to being well planned in this kind of an environment. We can use something called a qualified disclaimer tool to leave some flexibility with the surviving spouse. We can make the funding itself in that way kind of optional, something that the surviving spouse makes the decision on once the first spouse passes. So the plans I put in place are very flexible. They accommodate both the federal side and the Washington side. and really allow the surviving spouse to make decisions based upon the law as it exists when that first spouse passes, as opposed to trying to predict what Congress or Olympia is going to do in the next 5, 10, 15, 20 years, which is virtually impossible. So very important to put this kind of planning in place if you're over those thresholds. And certainly work with your estate planner, your CPA, your financial advisor, and your attorney to make sure that all three of those folks are pulling in the same direction. I'll stop here and see if there are any estate tax issues, then we'll talk a little bit about Medicaid.
There's no questions on the chat bar at the moment.
Okay, great. So Medicaid is one of those topics where there's a lot of information out there. And believe it or not, there's a lot of good information out there, but that information often is conveyed incorrectly. So people know about the $2,000 limit that you can have, but they think that applies to anything. People know there's a 5-year look back period for gifts, and they think that applies in all circumstances. People think that a married couple has got to spend down before they can get long-term care for one of them if they become ill. A lot of these things are true, but with proper planning, you can really minimize the impact, particularly for a married couple, of providing long-term care that's funded largely by Medicaid and provides the care that's needed while not requiring the couple to spend themselves down to poverty. So we'll take a minute here and go through what would we do with a married applicant, the person going into care, and then the other spouse. What's that look like? I will state from the outset, there is no good Medicaid reason to get a divorce. There are perfectly legitimate reasons to get a divorce. Medicaid is not one of them. And so if people are telling you that you're going to have to get divorced, that's the only way out of this, that's wrong. Sit down with an elder law attorney, take a look at your assets, take a look at your circumstances. There is always a way to plan that does not involve divorce and does not involve poverty. How is that so? Well, people know that a married applicant can have $2,000. Their spouse, however, can have a lot more. The public policy behind all this is that Congress wants to pay for one. They only want to pay for one spouse. They want that other spouse to take care of themselves. So Congress isn't being nice with these rules. They just don't want to deal with having to care for both spouses. They'd rather the spouse not in care be self-sufficient, and then they can care for the spouse that needs long-term care. So the spouse has got significantly higher limits. The spouse can have a house of really any value, an automobile of any reasonable value, about $70,000 to $130,000 of liquid assets outside of the exemptions, in addition to the other exemptions. Now, what you're thinking, what if you've got a $500,000 brokerage account? What you can do is you can put the excess over this $70,000 to $130,000 into a special type of annuity called a SPIA. That annuity pays back to the spouse not going into care everything you put into it over 5 years, plus a little bit of income. And that SPIA, whatever's in the annuity, does not count against the application. So if a married couple has a house and a car and $300,000 in a stock account, in that case, you would put $230,000 of the 300 into one of these annuities. And then 1/5 of that 230,000, which I think is 46,000 per year, would get paid back to the spouse. And so at the end of the 5 years, they've got all the money back out of the annuity. They're right where they started from, and Medicaid is not going to come and count again. Why? Again, they want that spouse to be self-sufficient. So if that spouse lives for 5 years and gets all the money back, then Medicaid's happy. They're paying for the one spouse, the other spouse is taking care of themselves. But you ask, what happens if you die within those 5 years, the spouse not in care? Well, in that case, the state of Washington is the beneficiary of that annuity for anything left inside of it if the well spouse dies within the 5-year period. And you can kind of see the public policy behind that too, where we'd like for you to be self-sufficient, but if you pass on, that's not such a care anymore. So the feds would like some money back. And so that's the reason why they want you to lock that money up for 5 years. You get 1/5 of it back per year. And if you live the 5 years, then you're free and clear. So you can have substantial assets and still get a spouse qualified for Medicaid. You can have a prepaid burial plan, burial plots, $1,500 cash value in a life insurance policy. Well, you think, what if it's a whole life policy and it's got a $70,000 cash value? Well, you can take a loan against that policy, put the loan proceeds, if they put you over the limit, into that SPIA, get that paid back, pay back the loan on the policy. And if you live the 5 years, again, you're free and clear. This makes a lot of sense if the cash value of the policy is significantly less than the death benefit. You don't want to give up that death benefit. So you're able to keep the policy in place without having to cash it in. If it's a term policy, they don't really have any cash value, and so it's not going to count against you for qualification. Personal property, if you got the Hope Diamond, maybe we should talk about whether or not you need Medicaid, but really personal property of any reasonable value. And unlimited income. So the spouse not going into care, the income limits do not apply. Now, if the spouse going into care has income that's over the limits, and we're talking $10,000 to $12,000 a month of income, then qualification can get a bit tough. Because the way it works is the spouse not going into care is assumed to need around $3,600 after mortgages and utilities in order just to live. And so if the spouse not going into care doesn't have that income, if it was the non-working spouse, for example, then they can keep a portion of the spouse who's going into care, keep a portion of that income to get them up to that limit. Now, once the spouse has reached that limit, then the spouse who's in care, their income is going to go towards their care, minus about $90 a month for a personal needs allowance. And then Medicaid pays the difference between the spouse's income going towards their care, their contribution, and the Medicaid reimbursement rate. So to put numbers on this, let's say that the spouse going into care has $5,000 a month of income. The spouse not going into care doesn't have any income or very little Social Security. They would keep $3,600, $1,400 of it, the remainder, would go towards the care of the spouse who's in care, and then Medicaid would pay the difference between the Medicaid rate and $1,400. So the income rules can get a little bit complex, but again, the whole public policy is to allow the spouse not going into care to be self-sufficient. So no need to go broke and no need to get a divorce. Now, for a single applicant, the limits are about the same as they were for the spouse not going into care, but the assets that single person has that are not required to be liquidated before you go on Medicaid, there's going to be a Medicaid lien that's going to attach to those assets, particularly the house. So if someone has a house, there's a chance they could return home at some point, and they go into care funded by Medicaid. Medicaid may not require the sale of the house, but they are going to put a lien on it so that once the person passes and the estate sells the house, Medicaid will take right after any mortgage holder. So that can be kind of onerous for a single applicant. I note that for a married applicant, there's no lien because the spouse who passes on didn't own anything. It's all owned by the other spouse as separate property. So Medicaid liens are not a problem there. And there's a policy that Medicaid has of not putting a lien against a surviving spouse anyway, but this makes it pretty rock solid. What's the planning look like for a couple who are concerned about Medicaid and long-term care, maybe not as concerned about estate taxes? Well, it's going to look similar, but with a much different type of trust. Instead of leaving everything outright to each other, think of the circumstance where you do all this transferring. You've got a well spouse and a spouse going into care. You've transferred everything to the one spouse, and then that spouse dies, and they've got an I love you will. Well, all those assets come back to the spouse who's in care. They come off Medicaid, they spend themselves down, and they can go back on Medicaid, but the assets have been spent for their care. If you use another type of plan, a supplemental needs trust plan, that doesn't need to happen. In that circumstance, it's what's shown here on the slide. The decedent's community half of the property, in this case, we'll say $350,000, $700,000 estate, goes into a special needs trust for the surviving spouse. Now, the surviving spouse cannot be the trustee, and that trust is highly restrictive. It cannot be used to pay for anything that Medicaid would otherwise pay for. So the trustee has sole discretion whether or not anything comes out of that trust, and the surviving spouse cannot be that trustee. So in a circumstance where you've got an otherwise healthy couple and one spouse passes on with this type of planning in place, there can be a slight loss of autonomy. And I make sure my clients understand that. The benefit, however, is that let's say the surviving spouse does need long-term care. They would spend down their half of the assets first, and that supplemental needs trust would not be counted against them, and it would not be subject to a Medicaid lien. So it could increase their quality of life while they're in long-term care, and it would pass on to the beneficiaries of the couple once the second spouse passes on. If you've transferred substantially all the assets to one spouse and that spouse dies and you have this plan in place, you've protected largely the entire estate from either Medicaid disqualification or a Medicaid lien. So again, the downside to this type of plan is that there is a loss of autonomy if the surviving spouse is still healthy, but the benefits in most cases outweigh that loss of autonomy for the surviving spouse. What do you do if you're single? All this has been focused on married couples. Well, unfortunately, the planning opportunities are much more limited. Two that spring to mind: if you have a dependent child, you can transfer your primary residence to that dependent child. However, if disabled child, that can affect their ability to get disability on their own regard. The other exception is if you are going into long-term care and you can show that a child lived with you in your primary residence for a minimum of 2 years prior to going into care, and but for them living with you, you would have gone into long-term care 2 years prior. Typically, that's done with a doctor's letter. Then the primary residence can be transferred to that caretaker child without penalty. Pretty narrow exception. So in most cases, we don't have those to really fall back on. What we can do, though, is make a gift to children or a trusted individual and have that person, after an applicable period of time, establish a supplemental needs trust on the part of the donor. And then you try to wait out the 5-year period. So if the donor doesn't need care for 5 years, then the gift isn't disqualifying because it occurred more than 5 years prior to the time the application is made. If you do need care within the 5-year period and you do need to apply for Medicaid, then you would need to disclose the gift. So let's say that you make this gift, the trust is established, and 3 years later, you need long-term care. Well, if you have enough assets to pay for 2 years, you're good because you'll be through the 5-year period by the time you apply. What if you don't? Well, then you can use the trust to help pay for care to get you over the 5-year hump, and whatever's left in the trust at the end of the 5-year period is also free and clear of the 5-year look back. What if you spend down the entire amount that you have and you spend down the trust and you're still not over the 5-year hump? That's okay, because you can show Medicaid that although you did make a disqualifying transfer, it all came back and was used for your care, in which case it won't disqualify you. So I use a trust because the thought of calling a child 3.5 years after you've made a large gift to them and wanting it back, you can sort of run the calculus on that if that's going to work or not. But if it's put into an irrevocable trust, you know where it is and that child can easily get to it. So I'll stop there. Last topic is going to be IRAs. If there are any Medicaid questions, key takeaways: lots of planning opportunities for a married couple. No need to get divorced. No need to go broke.
No questions on the chat bar.
Okay. We'll close off with a discussion about IRAs. They have really become a significant estate planning piece. I won't say a tool, because realistically, IRAs were designed for retirement. They were never designed really to be inherited. So the rules around inheriting IRAs are kind of clunky, and you got to work around them in a lot of cases to make an estate plan work. Looking at the numbers here, at the 2021 peak of the market, which we're about right there again, there was nearly $40 trillion in retirement plans in this country, and 13.9 trillion of that was in IRAs. And compare that to 3.7 trillion in 2007 and 7.6 in 2015. You can see that IRAs are exploding in value as people roll 401ks into them. We're more and more into the generation where we're going to find out if you can save for your own retirement. Pensions have by and large gone away. And so that's kind of what we're entering. It's a big experiment. We'll see if it works. IRAs don't pass under your will. They pass by beneficiary designation directly with the IRA custodian. So know that if you've got an old beneficiary form out there and you die, that's where that IRA is likely going to go, even if circumstances have changed significantly, including potentially a former spouse, if you don't update your beneficiary form after a divorce. In a lot of cases, state law will come in and kind of rescue you from yourself if you forget to do that. IRAs are a group where that state law may not apply, and that beneficiary form may still have that IRA go to your former spouse. So make sure your beneficiary forms are up to date. They're not subject to your estate creditors. So if you pass on and you've got debts, your IRA passes free and clear of those debts to your beneficiaries. Now, it can be subject to the beneficiary's creditors, but not yours. So very, very powerful tools if used correctly, but not the most graceful estate planning tools because it just wasn't something that they're designed for. What are beneficiaries? What are permissible designated beneficiaries? Well, those are people, spouses, kids, parents, best friend, worst enemy, doesn't matter. As long as it's a human being, you're going to get the best possible rules for how fast that IRA has to pay out. And all of this is designed, you want to keep money inside of an IRA as long as you can because it's allowed to compound tax-free in there. And it can grow much larger than a taxable account, which is having to pay taxes every year. So you want to keep income, you want to keep money in an IRA, and you want to draw it out as slowly as possible for two reasons. One, even in a Roth, you lose that tax-free compounding. And in a traditional, as you draw it out, it's ordinary income. Certain trusts can be permissible designated beneficiaries if they're look through, which we'll talk about here in a second. They're specifically drafted to receive an IRA and allow you to use the rules of the beneficiary of the trust and not the trust itself. Non-permissibles, they get the worst rules when it comes to how fast they have to pay out. They have to pay out much more quickly on average than good beneficiaries. Those are estates. Never, ever, ever have your IRA payable to my estate. Don't do that. Take a look and see who your estate beneficiaries are and name those people at the very least. Payable to my estate is the worst rules. It's got to come out in 5 years in most cases. So not good. Charities, although charities and a traditional IRA can be a match made in heaven, charities have to liquidate an IRA pretty much when they receive it, and most trusts that are not drafted to receive IRAs. How fast do you have to pull an inherited IRA out? Well, even after the Secure Act, a couple good things did happen. The RMD age was raised initially to 72. Now it's 75. That is the age at which you must start taking money out of an IRA if it's your own. So it used to be 70 and a half, then it was raised to 72. And for certain individuals, it's now raised to 75. Spousal rules still in effect. So if your spouse dies and they've named you as their IRA beneficiary, you can just roll it into your own. It's as if that first spouse never existed. It just becomes your IRA. And you don't have to start drawing on it until you're either 72 or 75, depending on the applicable age. The downside to the Secure Act that was passed in 2020 was the loss of the stretch IRA, it was called. If you left an IRA to a non-spouse beneficiary, they could elect to draw the IRA down. They'd have to start the year after you died, but they could use their life expectancy to do it. So they could basically set themselves up with a lifelong pension if they were careful with the IRA. That went away. And for most non-spouse beneficiaries, the rule is now the IRA has to be paid out within 10 years of the death of the initial owner. There are some new rules that have come into effect as to exactly what that means. Is it 10 years 1/10, per year? Can you wait until the 10th year? A lot of that depends on the age of the person that died in the first place and whether or not they were at the required minimum distribution age themselves. But in any event, drawing an IRA down within 10 years is in most cases a lot faster than it used to be when you could use the life expectancy of the beneficiary. There are exceptions to that 10-year rule. They are surviving spouses, which I'll talk about here in a second, because you're thinking they can just roll over, right? Yes. In some cases, you may want to use their life expectancy, however. Individuals less than 10 years younger than the IRA owner, so if you leave it to your brother or sister and they're 2 years younger than you are, they can use their life expectancy. The next two are very important, chronically ill or disabled heirs. So we can still use IRAs to fund supplemental needs trusts, like we were just talking about, and still use the life expectancy of the beneficiary to try and slow down those distributions. And then minor children of the owner. So not just any minor, but minor children of the owner. They get to use their life expectancy until they hit 21, at which point then they've got to pull it out by the time they're 31. Roth IRAs follow the same rules. The only difference is when it pulled out, it's not income to the beneficiary, which is good, but it's still subject to the same withdrawal periods as a traditional IRA. So do we use trusts ever with IRAs? I've told you that most trusts are not good beneficiaries. Well, if they're specifically drafted, you can. If you leave it to a standard trust, you're either going to be looking at the decedent's withdrawal schedule, the so-called ghost RMD, kind of a fun, morbid rule for it. Or if the person had not yet hit their required age, then 5 years. So in some circumstances, I guess this could be longer than 10 years, but in most cases, you're going to be locked into that 5-year rule. And so it's a lot faster. But if you specifically draft a trust to be what's called a look-through trust or a see-through trust, then you can use the rules that are applicable to the beneficiary of the trust and not the fact that it was left to a trust itself. This used to be very valuable. You could leave an IRA to a trust for a child and know that that child would only be able to get the RMD based upon their life expectancy. And so if that child was really bad with money, excuse me, you could set up kind of a lifelong annuity for them. That use has gone away largely. There are very limited times you would use a trust these days, and there are two that come to mind. The first is an IRA conduit trust, and that is a trust which receives the RMD based upon the beneficiary's schedule and then immediately pays it out to the beneficiary. So that trust is just a conduit for the required minimum distribution out of the IRA each year. They're very flexible. We used to be able to, again, use these for spendthrift trusts for children who are bad with money, but now that that's got to come out in 10 years anyway, it's not that helpful. But we do use conduit trusts for marital purposes. Let's say a couple has a $3 million IRA, one of the partners has it, and a house. And so it's a taxable estate, but most of it is in the IRA. And if it just passes to the surviving spouse, then we're kind of back in that I love you will approach. If instead a portion of that IRA can go into a trust for the benefit of the surviving spouse, we can use the life expectancy of that surviving spouse to kind of time how fast that has to come out. And yet we're not stuck with a 10-year or a 5-year payout if it is the surviving spouse. Because remember, they were an exception to the 10-year rule. And this is a circumstance where you would not do a rollover. You wouldn't just have the IRA pay into the IRA of the surviving spouse. It would go into a trust. You would use the credit of the first spouse against it for estate tax purposes. And then when the survivor dies, that IRA would then pass on to ultimate beneficiaries, but would not be subject to estate tax. So very helpful if you've got a couple where an IRA is a substantial part of the estate, and particularly if only one of the married partners has that large IRA. Accumulation trust or the other type of trust, they hold on to RMDs. The RMD comes out of the IRA, hits the trust, and then it's the trustee's discretion as to whether or not it gets paid out. Now, trusts pay income tax at the highest possible rate very quickly, like about $14,000 of annual income. They're already up into the upper 30s, low 40s in income tax rate. So you don't want to hold on income into a trust if you can avoid it, but sometimes it's worth it because the other purposes of the trust outweigh that. The biggest example of an accumulation trust is a supplemental needs trust for a beneficiary. You can leave an IRA in there. You get to use the life expectancy of that beneficiary to slow down the RMDs that are coming out of the IRA, and the trust can hold on to those RMDs so it stays qualified as a Medicaid trust. So really with IRAs these days, only two circumstances that are typical of when you would use a trust as your IRA beneficiary. One is if you're very, very heavy in the IRA and you're potentially taxable. The other is if you're trying to set up a supplemental needs trust for either the spouse or a child, and you'd like to use an IRA to fund that. You would draft an appropriate trust in those two circumstances. Finally, IRAs and charities. I said that a charity and a traditional IRA are a match made in heaven, and they are. Because if you've got a particular percentage of your estate you'd like to leave to a charity, and you've got a traditional IRA, what I tell clients is, let's not put the charity into your will. You've created another beneficiary, you've got to give them notice. Charities can be slightly painful beneficiaries because they're required to make sure they're getting all they're entitled to. So they want accountings and things that family members often don't want. So they can be kind of painful to have inside of the probate process. If instead you can designate that charity as a beneficiary of your IRA, either all of it or a percentage of it, then when you die, the IRA custodian contacts the charity, sends them their share. The charity sends a very, very nice thank you note to the estate, and the charity goes away. And you've taken care of your charitable bequest without including them in the process, and charities don't pay income tax. So that traditional IRA, the amount going to the charity goes free and clear of income tax. Whereas if a portion of the house sale went to the charity and a portion of the IRA went to the charity and the child got a portion of both, the child's going to have to pay income tax on that traditional IRA. So if you can instead carve out a bigger role for the charity in that IRA and leave all of the house to your child, for example, then you lower the overall income tax hit and everybody's better off. Finally, IRAs and durable powers of attorney. Take a look at particularly your older power of attorney. If it does not specifically address IRAs and qualified retirement plans, maybe it's time to update. In the old days, IRA custodians would allow the general banking powers to kind of allow your attorney, in fact, to administer your IRA. Not so much anymore. They want to see specific powers within that IRA. So maybe it's a time to update, include those, and make sure that your power of attorney is up to date. So next step. So that concludes my presentation for today. Mary's going to stay on. I'm going to sign off here in a couple of minutes. I